Most, I regret that we did not include the digital euro. You see, I just read that the European Central Bank decided that the digital euro will be introduced in 2029. That's the final decision. And no one knows what, legally speaking, the digital euro is. The European Central Bank calls it, and for property lawyers among you, and because as you know, property law is the most fascinating topic that you can teach. But according to the European Central Bank, the digital euro is a non-physical in-RAM asset. Non-physical in-RAM asset. So what are we talking about today? So we're not going to talk about the digital euro, we're going to talk about liability questions concerning AI. Questions about AI and governance, and questions on shadow AI. So we're quite interested. So the first speaker will be Professor BÜYÜKSAİŞ, and he'll speak about liability for damages caused by AI systems. The floor is yours.
Thank you, Mr. Chairman. I would like to thank the organization committee for the great job they did by gathering so many important lawyers for this conference. And I'm truly humbled to have been invited as one of these speakers. And my special thanks go to the Vice Dean, Professor Erdem. Over the next 20-25 minutes, I will quickly examine civil liability in the context of AI and try to cover an expansive range of topics related to the use of AI. I will try to adopt a holistic and down-to-earth approach to the legal issues. I will discuss first what can go wrong with an AI and what will be the damage. Then I will show you how different legal systems, particularly Turkish and European regimes, cover the remedies available for non-contractual parties. I will put aside the contractual remedies, solutions, since we cannot know beforehand what contractual remedies are offered by any contract. So I will start with the challenges posed by autonomous systems of an AI. And then I'm going to briefly touch upon Turkish Product Safety Act as well as the Swiss Product Liability Law, which both don't offer any specific solutions, challenges posed by AI. On the other hand, the legislator in Europe adopted a new directive on product liability. To be honest, this is not a new directive, but it revised the existing 1985 directive. And this EU directive on product liability is extremely important for two reasons. First, it defines software, among others AI, as a product. And that indicates a shift in the paradigm because up until now in Europe we always thought that supplying a software would be a service. From now on, the directive is enforced in December 2016. From next year on, it is not a service anymore, it is a product. And the second reason why the directive is important is that it can be a model for the Swiss and Turkish legislators who don't offer any AI-specific solutions to the challenges posed AI. And then if I have some spare time, I would like to talk about the vicarious liability for organizational defects. This is Article 66, paragraph 3 of the Turkish Code of Obligations, which is quite interesting. And there is, as far as I know, to my knowledge, there is no comparable legal provision in Europe like that. That offers a general solution, but it's still applicable in cases of AI. As you know, AI needs to be fed constantly by data, and that can create a problem for IP holders, especially copyright holders. Therefore, perhaps talking about Article 70 of the Turkish IP Act could be relevant. And using AI can lead also the abuse of dominant position of the company, the business, which uses the AI. Therefore, I would like to briefly touch upon the Turkish Competition Act as well. To me, there are two types of challenges, factual ones and legal challenges. On the one hand, AI autonomously develops new solutions to problems. There's absolutely no discussion about that. But on the other hand, the self-learning ability of AI poses a tremendous challenge for operators as well as developers who are not always able to anticipate the risk that AI poses for others. When I say developer and operator, I would like to explain this with a quick example. For instance, this iPhone, you receive from time to time an update. The manufacturer of this update is the developer, and the business, the company which makes profit with it, with this update, is the operator, iPhone. And then there is a user like you and me. So updates are good examples to explain the post-marketing phase of AI, since AI needs, as I said, constantly to be fed by data. AI can become defective even after being put on the market due to data issues like bias, as we discussed this morning during the morning session, or poor quality data as well as inherent imprecisions of the model used, and of unforeseen real-world complexities. From the technical standpoint, it's extremely difficult to analyze the actions taken by AI, which led to a damage because the decision-making process is not yet entirely perceivable from outside. It's locked in a black box. This is why it may already be very difficult for a claimant, when I say claimant, obviously this is a layperson, not an engineer like Altan Çakır Hoca this morning, to prove that the output causing the damage was artificially generated. You have certainly heard that some lawyers in the UK, but maybe in other countries as well, submitted legal arguments that relied on cases manufactured by AI. These stations bore all the hallmarks of real legal authorities, proper names, plausible quotations, and the style that appeared entirely authentic, but none of them existed. The stations were false, the cases were fictional. This was not an act of desperate lawyering to manufacture a winning argument out of thin air, but rather it was a dangerous shortcut done by AI. Now the question is, of course, how do the legislators in Europe or in Turkey or in Switzerland or respectively in your country deal with these challenges? The answer depends obviously on the jurisdiction, but the key question remains the same. Supplying a software, is that a service or is that a manufacturing process? What at stake is that if you say that it's a service, then you have to apply the rules applicable to services, the general rules based on negligence liability. Whereas if you say that this is a product, you have to apply the product liability rules, the specific rules that we have in Europe, and these rules establish a no-fault liability. Another problem here, the legal challenge, is who is responsible for what, because there are so many intervenants. When I talk about an update, for instance, there's this developer, the manufacturer of the update. Probably the manufacturer of the update manufactures the update, the software, with the instructions of the operator. I mean that it's probably a customized update, and then there is this user who may intervene, who may feed the software with inappropriate or with wrong data, then the outcome can be harmful. But who to attribute this harm now? To the developer, to the operator who makes profit with this software, or to the user? Can we say that under certain circumstances it's possible to break the causal chain because of the fault of the user? Another problem, as I mentioned, is burden of proof, which is normally on the shoulder of claimants, but for lay persons, claimants, it's extremely hard to prove the defect as well as the causation. How do we see if national laws can deal with these issues? Since I lecture in Switzerland, I'm familiar with the Swiss Product Liability Act, and here you see also the Turkish Product Safety Act, enacted in 2020. Purposefully, I jot down this 2020 because that shows that this is quite recent, enacted very recently, but very frustrating because it doesn't offer any solution to AI problems. Just it defines product as a tangible object, any substance, preparation, or goods. When you look at the Swiss version, you see a very similar definition, but which was enacted in 1993, and at that time, such a definition would be normal, I would say. So there is no specific solutions here. There is no definition of software. Software is not included in the definition, into the definition of product. But somehow, even though it's contrary to the wording of these definitions, some lawyers in Switzerland, as well as in Turkey, and maybe in Spain and Italy, they say that software should be considered as a product. Though this interpretation would be against the wording of these definitions. But again, the content of the scope of application of these directives are blue. On the other hand, if you look at the new product liability directive, which revised the previous one of 1985, you see a very new definition, a very modern definition of product, which says that digital manufacturing files as well as software should be understood as a product. Here, one of the questions coming up is whether the bespoke software products, customized software products, are also products in terms of this directive. The answer is yes. When you look at Recital 13, it says that irrespective of the mode of its supply or use, software is a product, then the customized related services, customized software should be considered as a product as well. And when you look at this Recital 12, you see that AI was explicitly mentioned as a software and in turn as a product. Though the directive itself doesn't provide any definition of the AI, which is a good thing because these definitions are not future-proof. Had the legislator defined software in 1999, it should have said computer program. But this computer program would be outdated already. So I find this solution to give some room to the judge quite normal. There is no definition in the new EU directive on product liability, but if you really want to see a direct definition of AI, you can look at Article 3, Paragraph 1 of the AI Act. There it says that it's a machine-based system which is capable of inferring from the input it receives and generating outputs, which separates AI from other types of software that we use, like Microsoft Excel or Microsoft Word. There are some exceptions to this definition, broad definition of product, which includes software and AI. Open source software are excluded explicitly by Article 2, Paragraph 2, though that wasn't necessary to my knowledge, because anyways this directive excludes products put into circulation without any commercial purposes, but that enforces the idea to support academia probably. They explicitly mentioned that open source software is not considered as a product, therefore there is no strict liability for the operators and the developers of such software. Pure information, this is very interesting. It explicitly says, the directive in Principle 13, pure information and mere source code of software are excluded as well. I think the main idea behind that is that the information needs an interpretation. Information itself cannot be dangerous, cannot cause any harm, but the way you interpret the information can cause a harm. Therefore, these are not products. But there is then one exception to this exception: digital manufacturing files. Although these are files and information, they are considered as a product. These are the 3D versions of natural legendary objects. I mentioned here CAD files. CAD is the abbreviation of computer-aided design software to create 3D goods. These are considered as a product. I don't know if the distinction between information and product is realistic. We will see that. Related digital services are considered as components, and since components are components of the product, the manufacturer of the whole product with these components are responsible for the damage caused by AI as well. And there is a definition of these digital services. They must determine the safety of the product. If they are regarding the performance of the product, they are not considered as a product in terms of this directive. They should be integrated into or interconnected with the product, and they should be within the control of the manufacturer. If they are out of the control of the manufacturer or the developer, they cannot be considered as a product. And I mentioned here 3 examples. Let's take the health monitoring services. You certainly have Fitbit watches, or some patients, they wear constantly some gadgets which give some information to their doctors. Let's assume that the appliance, the gadget, the appliance is intact. There is absolutely no defect on it, but the software interconnected to this device is defective and doesn't give the right information to the doctor, and let's say because of the heart attack the patient dies or gets unbound. In this case, the manufacturer of the device itself is responsible also for the defect of the defective service it received to commercialize its product. Of course, after all these definitions, the legislator, EU legislator, also adopted the notion of damage and added some new heads of damage to the directive. One is damage to psychological health, and the other one is even more interesting: destruction or corruption of data that are not used for professional purposes. These are the new types of damage which can be covered by this directive. And here one question coming up is whether pure loss of data can be considered as a destruction of corruption. I would say yes. We will see this with the decisions handed down by the European Court of Justice soon, but I would say yes, pure loss of data can be considered also as a damage. Here the problem is quantum, calculation of quantum. If you lose some data, or if your data is corrupted because of a defective service or defective software, you can, of course, sue the manufacturer of the software as well as the operator. They are jointly and severally liable. But how to quantify the loss? When it comes down to financial loss, it's quite easy, though it's not always easy when it comes down to medical data, lost medical data, for instance. There is one more interesting legal provision in this directive. There are many, but I'm not able to cover all of them with you. Defects liability period. Normally, to assess the defect, we take into account the moment where the product leaves the control of the manufacturer. From that on, normally for stable products, for this, for instance, the manufacturer is not liable anymore. But since AI develops itself for a long period, and therefore we don't use the term end product or final product. There is, if you talk about an AI, there is no more end product, no more final product. Therefore, the legislator, European legislator, created an exception to the defense mentioned, stated in Article 11, paragraph 1, letter C. It says that this defense, what I said, is void if the manufacturer remained in control of the related service. Even if the product was already put into circulation and became defective later on, the manufacturer should be liable if he or she has his or her hands over this product, which is often the case with software. There are some presumptions to ease the burden of proof, which is normally on the shoulder of the claimant, and Article 10, paragraph 2 says that if there is a failure to comply with the requirement to disclose evidence, this is quite new, non-compliance with the mandatory safety requirements, or if there is an obvious malfunction of a product, there is a presumption of defectness. Then it's the manufacturer of the software or the company which makes profit with it, operator, should prove that the defect is not attributable to them. There is one more, this is even more interesting. If the claimant faces excessive difficulties because of a technical or scientific complexity, then also this claimant may benefit from this presumption. Okay, this is what we have in Europe, and now in Turkey, this is the vicarious liability for organizational defects that I talked about a couple of minutes ago. I would like to read Article 66, paragraph 3 with you. This is, by the way, totally independent from the employer's liability. This is something else, organizational defects liability. It says an employer in a business there is always an employer and an employee. Without, I cannot imagine. Has to compensate the damage caused within the sphere of the activities of a business. Up until here, it's clear. Please pay attention from here on. Unless he proves that the organization of such business was appropriate to avoid the occurrence of a damage of this type. Here. If the damage had already occurred, would that be possible for the employer or manufacturer, if you want, to prove the contrary, to prove that he took all the necessary precautions to avoid the damage? The answer is no, because the damage is already there. If the damage is there, that means that perhaps you were able to do that, but you didn't do that. You didn't avoid the damage, occurrence of the damage. So this is a pure aggravated no-fault liability, if you want. The wording gives the impression that the employer may bring a cause to exonerate, to escape the liability, but if you read carefully, it's not the case. So this is a general legal provision which is applicable also to organizational defects but also the problems caused by AI in Turkey. There is this IP Act. I would like to share this with you because of this new, very recent and very hot topic case, New York Times versus OpenAI. You certainly have heard about this. New York Times sued OpenAI because OpenAI used the data, the articles and news published by New York Times, though without permission of the newspaper. And it's the same when the data feeds itself, when the AI feeds itself with the data once it's on the market, it can cause a violation, copyright violations, especially when it finds an information and when it thinks that it's necessary for its development, for its decision-making process. So what's the solution? The solution, Europeans found a solution to that, and is that you certainly know much better than me, but I think as the copyright holder you should put a watermark, machine-readable watermark on the internet if you publish your work on the internet, and then when the machine sees this watermark, either it carves out this data, doesn't take it into account, or asks for permission. That can be a solution in Turkey as well. Competition Act can be applicable, especially Article 6. I don't know if you heard about individual price fixing. Since I fly a lot, I'm a very frequent flyer. Therefore, and I use almost always the same company.
I'm sorry to
yeah.
But I already gave you 5 extra minutes.
Okay, this is my last slide, and then I will conclude. So this individual price fixing is determined via cookies. They get your information, everything on you, your budget, the color you like, the seat you like, the food you like, everything, and then they individualize the price just for you. This is not dynamic pricing, this is quite something else. I experimented this with my wife. We looked for the same flight at the same time, exactly the same service, different prices. This can be contrary to the Competition Act. By the way, the article and the legal provision that you see is the exact same as the 102 Treaty of the Union or European. I will conclude. There is no longer fault-based liability for the damages caused by AI. It's based, at least in Europe, it's based on the Product Liability Directive, which set for a strict liability. And this is a big shift in the paradigm because the furnishing or manufacturing and supplying the software is not anymore a service. It's considered as a manufacturing process, and therefore the outcome is a product. Thank you.
So software, as you said, is a service. As a software as a service. And we see indeed a complete paradigm shift from software to being a product, because it's very often so connected with the physical thing that it's almost impossible to disconnect the software from the thing itself.
Exactly.
And I think you showed that extremely clearly, so thank you very, very much for that. The second speaker is... okay. Right. Okay, so we changed the order because the PowerPoint that was uploaded for the second speaker is the old version, and that will be changed with the newer version. Right, so up to you, and you're going to talk about shadow AI, yes. So let's see. Okay.
Thank you very much. dear guests. First of all, thank you for the invitation and for this lovely organization. I want to talk about shadow AI, which sounds very fancy and very new, but it is something we are faced every day in every company, institution, school, university, everywhere. I want to start with a simple example. I'm an employee of any company, and my boss comes to me and says, we have in 15 minutes our board meeting, and I want to see your presentation regarding sales results. I have already prepared something, but it's not beautiful enough. So what do? I make a quick Google search, download or make it as software, use the software as a service, and upload my presentation. Which transforms with AI my presentation into a very fancy, very lovely one, and now I can go into the board meeting and show all my information. I can use my lovely presentation. So what's the problem with that? The problem is, and now we are already within the definition of shadow AI, it's a growing trend where employees are secretly using powerful AI technologies without any oversight. So what's the big deal about that? I'll come to it. But the term shadow AI comes from the original term shadow IT, which is also the same, that employees use IT technologies which are not permitted, which are not controlled by the IT department, by the company, or by the company policies. And this unsanctioned or ad hoc use of generative AI within a company, emerging with the popularity of tools like ChatGPT without formal approval, or the green light of the IT department or management, can cause serious problems for all companies. Just to give some numbers, 77% of employees share company secrets on ChatGPT report boards. So that's what we are seeing day by day, that employees have to finish their work very fast, and then they use different AI technologies. It can be OpenAI, it can be Copilot, Gemini, or anything else as a startup, a little startup company which can give us different solutions. And employees regularly paste company secrets into ChatGPT, says another one, but not so much Microsoft Copilot. We have JP Morgan, which restricted employees from using ChatGPT, and another interesting example from Samsung. There were some IT guys who wrote their codes, but they always had some bugs. They want to, they're creating a new code, they are writing a new code, but they have difficulties, they have some bugs. What are they doing? They are uploading their whole code to ChatGPT or Gemini and debug this code please for me. And so I have my new code for my new product, but Gemini or ChatGPT also owns all this data. So once again, what's the big deal about uploading all this information, transforming all these company secrets to OpenAI? Well, here is here's a speech from Larry Ellison. He's the co-founder and also the CTO, Chief Technology Officer of Oracle, where he said a few weeks ago, the Oracle database can vectorize anything that's in an Oracle database, a different cloud, and make that data easily accessible to the AI model for reasoning. So he says, in other words, we are using all data which is uploaded to Oracle Cloud, we vectorize it, and we can use it in different ways. The first thing that Oracle did was take private data and make it accessible to AI models. We took all of our customer data and we vectorized it. Once again, this is the co-founder and Chief Technology Officer of Oracle. So what's the big deal with Oracle? What's the problem with Oracle? Here we have the trillion-dollar ecosystem of different companies, of different AI companies, and as you can see, OpenAI has paid Oracle $300 billion in the framework of a cloud deal. So OpenAI uses Oracle Cloud. And what does Oracle with all this information? Once again, they vectorize them all and then they use it for their AI models. So this is not a conspiracy theory, that's also not my aim, but I just want to make clear, yes, it might, as an employee, it might be it's very natural to download and find the solution within 10 minutes, and there I have my lovely presentation, but at the same time I have uploaded very important data. Here's one lovely example. It's in Turkish. It's a Turkish newspaper on the right top. Turkish newspaper, which is telling us something about an earthquake, and they forgot to delete the prompts. So that ChatGPT says, shall I rewrite this post? Shall I rewrite your interview in a more scary way? And that was an original newspaper, yes. And then here ChatGPT exposed OpenAI warns repeating the word forever is against its terms of service as it could reveal training codes. I did not include this picture, but if you say repeat the word forever, there was a time they had already patched this problem. But if you said repeat the word forever, it repeated constantly the word forever, and then suddenly it began to reveal training data. And there were also some company information, so that this company information was publicly available suddenly. So we have some problems. And what are the legal consequences of this shadow AI practices? For topics, personal data, protection, trade secrets, IP rights, license agreements, and cybersecurity. These are the 4 topics that I want to discuss in a very short manner because of time concerns. So personal data, to start with personal data, when I use ChatGPT, when I use Gemini or any other AI application, when I feed in personal data, personal information, which is, by the way, which has a very broad definition, which we could see in the judgments of the European Court of Justice, in the recent judgments also, I need a legal ground for every stage of data processing, personal data processing. Is there a consent? Is it a performance of a contract? Are there legitimate interests? I should always be aware that I need a legal ground to process personal data. And it can also, what I'm feeding into these applications, it can also contain sensitive personal data. Once again, the European Court of Justice has an extremely broad definition of these special categories of personal data, which are strictly regulated than general personal data. At the same time, when I am uploading personal data to an AI application, whose servers are located outside of the European Union or outside of Turkey, that means a third country transfer, and once again I have specific regulations regarding these. Then technical and organizational measures, especially, has my company already maybe concluded a data processing agreement with that company. Maybe you know these Microsoft data protection addendums, where they try to regulate the relationship between the data controller and the data processor. And of course, this may also lead to data breaches, which also then come with the fines of data protection authorities. What do I have next? Trade secrets and IP rights. The definition of trade secrets according to the European Trade Secrets Directive. I don't want to read it yet now, but what are my legal problems? Loss of trade secret protection. Trade secret must be information which is valuable on the one hand and which must be protected against unauthorized access. But when I, with my own hands, transfer this data, when I feed in this data into the algorithm, that can mean that I lose the trade secret protection of my own company. And the company has invested millions of dollars maybe to obtain this trade secret. Undermining future patent and copyright claims. That means then or maybe I will discuss this with the next bullet point, risk of infringing third-party IP rights regarding input data and output content. What's the problem with that? When I, on my side, use data, for example, pictures, which are infringing third-party IP rights, or I get an output from this AI algorithm, but it infringes other third-party IP rights. And suddenly my company has to deal with copyright claims from third parties they don't ever heard of, because an employee has secretly used an AI application. Conflicting ownership over generated content. What does that mean? I use a video generator AI application. At the end, I have a product, I have a video, I have an output, but now the AI company which presented me the service claims I am the co-owner of this video because you used my application, and now I also have a claim, I also have a property right on this video. And so these are possible IP rights conflicts, risks arising out of shadow AI. On the other side, we have license agreements, and this is now finally maybe more civil law. The problem is that all these free software on the internet mostly says in their license agreements that they can only be used for personal purposes and not for commercial purposes. So just imagine you have to convert a PDF file into a Word file. You have just 2 minutes, you have used it, you logged in with your own personal email accounts, you converted the file, and suddenly your company gets a writing from the AI company saying, just a moment, you were allowed to use it for personal use, but not for your commercial purposes. So that was a breach of the license agreement, and now you have to pay the bill. And so breach of contract and penalties are done at the typical results. And last but not least, cybersecurity. The European Union has enacted a lot of laws in recent time. Cyber Resilience Act, NIS2 Directive, then DORA. Some are very sector-specific regulations, some are horizontal regulations which cover all industries, all sectors. And shadow AI is, of course, a great risk for cybersecurity. First of all, for cybersecurity risk management, if it is uncontrolled, if it is not monitored, then this may also lead to cybersecurity breaches. Well, if I cannot control, if I do not monitor, I cannot handle and I cannot report and I cannot ensure compliance at the same time. And this is also against the principle security by design and security by default regarding cybersecurity obligations of companies. What are the solutions? There are already existing solutions. AI Act, Article 26, obligations of deployers of high-risk AI systems. Not manufacturers, but already deployers of high-risk AI systems. You have here a lot of points. The problem is that they are, as you can read, as you can see, they are restricted to high-risk AI systems. But as, once again, as you can see, the problem is not restricted to high-risk AI systems, but all companies, all universities, all institutions. So, all in all, independent from the AI Act's obligations, I think that AI literacy is very important to teach every personnel in an institution, in a company, at a university, everywhere else, how to use AI, what are the risks arising out of AI, an act which seems very an act which does not seem to pose a great danger may at the end of the day lead to a data breach. So every employee should know what are the risks when using AI. And every institution, every company should have AI policies regarding the use, regarding supply of AI tools, how to monitor, and also should have a risk framework to avoid these risks and problems. This is just another point. I don't want to discuss this, but I just want to mention it. In recent times, there are large layoffs, especially in tech companies, technology companies. And there are rumors that these companies are monitoring their own employees in the background. How do they write emails? How do they work? How do they reply to a customer? What do they speak when they are making a phone call with the customer? How do they deal with different problems? And then they develop their own AI algorithms, and then they say to their own employees, goodbye, we don't need you anymore because we have an AI application which can do all the work that you have done until today. I don't want to get into legal details, as I said before, but this will also be a very interesting topic, I think, which we will discuss in the next few months, years. And thank you for your attention.
Thank you very much. That was also very clear. It is, for those of you from the university, whether you are employee or students, a warning not to use software that is not licensed by a university to begin with. Right? Because by using non-licensed software, you create the problem of shadow AI with all the consequences. And at the moment, that might not be too serious. It could be. So be careful. That is essentially also the warning that implicitly you gave us. And also a repetition of what I said this morning, know what you're doing. Right. Well, thank you very, very much again. Now, the floor is to Professor Vincenzo VIGNIERI. And I think now you have the correct version of the PowerPoint, but the floor is yours.
Thank you, Mr. Chairman, and thank you also to the Faculty of Law for inviting me as a representative of the group of three scholars that we together developed this paper. Actually, it's a working paper that brings together, as I hope I will be able to deliver you three different streams of research. So I'm an assistant professor at the University of Siena, Department of Business and Law Studies, and my field of interest is management, accounting, public management more specifically. And the two colleagues of mine who together with me developed this paper are senior researchers in economic law. So the first challenge was bringing all together these three different streams of literature. within the idea of supporting the governance of interoperable payment systems with artificial intelligence. Of course, we are not here, and the paper has not the ambition to just suggest this kind of the use of artificial intelligence tools within this payment systems, but also to reflect and to propose a framework in a way that some caution can be put into the discussion on how to use artificial intelligence in the system. And this comes from the idea that information payment systems are populated by different actors too, which share, most of them share different information. In fact, it configures a sort of information markets. And all this information should be put in order, and artificial intelligence can provide some support in that direction. This is our understanding of this. But let's move to the motivation of the work. So we started from the evidence that fintech has the potential to compromise the governance of interoperable payment systems, and we know that more broadly speaking, the digital transformation is disrupting so many sectors of our societies, including, of course, the financial systems. And interoperable payment systems are profoundly changed by the by fintech, which is a natural evolution of the electronic payment system, which nowadays is very popular and used by many of us. And as I said, the main purpose of the paper is to consider artificial intelligence as a tool to support the role of oversight authorities within the system. And we explore this problem from the perspective of accountability. By accountability, I want to make it clear from the very beginning of the presentation, by accountability we mean a relationship that exists between an actor and a forum, so an agent and its principal, basically, his or her principal, and this relationship configures a communication between the two, through which the actor can explain to the principal the rationale of the decision that has been taken. And also the actor is open to the possible consequences, such as sanctions, provided by the forum. So this is configured a sort of mechanism, a relationship between the two, that enables some of the discussions that were specifically carried out during the during the last session of this morning conference, particularly related to the constitutional issue associated with the use of AI. In fact, this mechanism enabled the trust towards institutions, in that case, public institutions. In this case, we are talking about something which is highly sector, which put together some actors from the private sector and other actors from the public. And we explore pros and cons of this scenario more in detail, of course, in the paper than in the presentation, to just give you some insight into that. So, a couple of notes on the design of the research, the methods and the contribution that we expect to deliver to the community. First of all, as I said, we draw from three different streams of research: economic law, management, and accounting. And we carried out a literature review of ESG risk associated with the payment systems. And we developed a case study related to the EU payment system, which configured the setting where we want to test, maybe in the future with another paper, the friendly accountability framework that we suggest for the adoption of AI tools as a supporting device for the oversight authorities. And also we developed a literature review on the ethical concerns associated with the use of AI in the decision-making process. This set the stage for the three different factors that we identify and that can provide some implication at the border between the regulation and the management of these institutions. So it's in between, somewhere in between. So we can use some insight from a law point of view and specifically from a managerial point of view, also from the governance point of view. The expectation is that we contribute to the further knowledge on the payment system governance, as I said, from the accountability perspective. Just an overview of the focus. So we focus on the interoperable payment system as led by technological infrastructure. Here we have the fintech application that operates as a platform between the payee and the payer, and other actors such as banks and wallets and third-party providers that interact together with the fintech application. This the interoperable payment system is a sort of house for the cost, we could say, a regulated activity, which is the provision of payment services, which are within the EU framework, are regulated by specific discipline. I don't want to expand my time on this because it's something that is well known to you. And but I want to just to put my attention on one critical point, in a sense that we use as the stage for putting forward our reflection, and is the last sentence. So the way this market is regulated set the stage for a transaction of information. It's a data market, and therefore there are a lot of information that are shared between these actors, and the oversight authorities might not have been access to all the information, or this could create some asymmetries between the different players. So artificial intelligence can be a tool that could overcome these information asymmetries. However, first of all, I want to frame this issue more clearly. This is also associated with ESG perspective. I was forgetting to mention this. We can have three different layers of challenges. One at the payer-payee relationship layers, or the user level, which is the micro level challenges. One at the meso level challenges that we refer to the interoperable payment system, and the third one, which is the G factor, meaning the governance level, which is the upper one. So the challenge is how to make the governance of the payment system sustainable in terms of well-informed and accountable and stable. So this is the stage, as I said, of our focus. The first two levels, and then we just focus on the governance point of view. So I was saying that how to use artificial intelligence within the governance of interoperable payment system, we could use it if, with a big condition, if the tool that we use are accountable. Accountable means that we are able to explain, in a sense, the rationale that is behind the performed actions or the decision taken by the oversight authorities within the systems. And before diving into that, I want to give a very brief definition of artificial intelligence. We're used to call it artificial, and we use the noun intelligence, but we know that when we use artificial intelligence, there is a coupling, there is a technology operates as a decoupling power in terms of splitting the task that we have to perform and the intelligence that is needed to perform the task. Of course, when the human is in charge of the task. So this means that the artificial intelligence is just a general term, a commercial term for, let me say, a product or a service, or specifically that we use to refer to a broad set of technologies and that are useful for solving a problem. And it is everything but intelligence, meaning that if we can use and we can advocate, we can call artificial intelligence when we need it, it means that that specific task could be so routinized that it does not require any kind of intelligence anymore. And by intelligence, I mean the intelligence that all of us experience in all the different settings of our daily lives. So from professional activities, even from emotional ones. So we have a broad range of nuances of intelligence, and that kind of machine is not intelligent at all, since we can make it very routinized. So artificial intelligence is a marketing term to commercialize something that is not intelligence. Totally the opposite. Is someone who say that it is the continuation of the human body outside of the body. From a philosophical point of view, someone would define it as a mesosomatic instrument. So that allow, like an electric guitar, allows someone to perform what is inside, not per se the instrument to do something else. And as I said, it decouples the ability to solve a problem from the intelligence that is needed to solve that problem. So we could use within systems that are populated by information that needs some kind of orders, rather than carrying out the truth, as another perspective, techno-optimistic perspective would call. the technology more broadly and artificial intelligence as well. So technology and artificial intelligence are useful for providing order to the information that we have rather than providing the truth. It's the human that has to say what is the truth or not when someone approaches information. More specification on the AI at a technical level is not my field, but we can understand that within AI we have so many lines of code, and if we take not a systemic perspective, a holistic perspective on the training AI, we could make we could mislead it, considering that we can understand single lines and try to have a meaning from the individual lines of code, but they do not have any kind of meaning in isolation because they work if they are put together. And even in this perspective, from a technical point of view, we are not able to allocate the responsibility for the feeds of the software on a single, as you mentioned before, on a single developers, because it's a result of the effort put by different players or different software houses when we look at the specific software. And more challenges related to that I will present in a moment. And how they render the inputs, so the data that they use into outputs, remains unscrutable for human reasoning, considering the fact that we are not able to fully understand how the tool works. So it creates, as the literature said, it creates a new contested terrain of control over data collection, so what kind of data the tool uses, the process of how such data are managed, handled by the software, and the use in terms of the actual use, the embodying of this information within the real decision-making process within the institution, like the one we are considering in this work. So all of these concerns have been investigated within the literature from an ethical point of view, because they refer to the values that are embodied within the tool. So for me, from my point of view, it's correct to approach this kind of issue from an ethical perspective. What kind of values the decisions that we have put in place? And this kind of concern has been identified at 3 different levels. So the first one are the epistemic one, related to the data collection and analysis method. So which way the knowledge that empowers the AI tools is generated, and to what extent, as we will see in a moment, is valid. The reliability of the information that the AI tool is using, and we also saw a couple of examples in the presentation that was given before mine. Also normative issues that are related to the explainability of decisional outcomes. So how this information, how the evidence has been put together to inform a decision. So what kind of evidence were brought on the table of the decision maker who took the decision. And lastly, the traceability of the responsibility for the performed actions. Meaning that if I took a decision for which I'm responsible as a manager of an organization, or as someone who is seated on the body of the oversight authority, and on my desk there are some evidence put on paper, but they are printed from AI tools, how, to what extent I can trust this information if I do not know how this data has been rendered and transformed into outputs that support my decision. So who is actually responsible for the decision that's been taken? And of course this question cannot be left saying that the computer said so I have to comply to what there. As some cases related to the judicial system, some of these problems were mentioned in the presentation that one of the colleagues gave this morning related to the constitutional applicability of AI and the human rights. If I remember well, it was the third presentation. I don't remember the name of the colleague, but still it was in his presentation. So all of these issues are things that we have to consider, are elements that we have to consider when we want to use artificial intelligence tools to support the oversight authority. And we put all of this information together all these elements that we gathered from a systematic literature review of the use of AI to support decision making within institutions, and we come up with three main factors that have an influence from the left to the right. So we have the knowledge validity that put together all the elements related to the epistemic issues, the decisional outcome explainability that relates to the balance associated with the normative concerns, how the evidence are put together to support the decision, and the third one, as I said, is the core, the last, the final result, which is the trustability concern, to what extent the human actant is responsible or not for the decision that has been taken. There is a relationship between these three factors, so we start from to a higher level of knowledge validity. So the more reliable is the source of knowledge that I use, the more I'm able to explain the decision I will take, and this will have this will provide lower degree of agency to the algorithm, to the AI tools. The opposite, of course, in the case where I start with an inconsistent data source, for instance, where different databases are used together to nurture the logic behind an AI tools. So we set this framework as a way to inform, on the one side, as I said, the regulatory activities, on the other side, even the management. And this means that from a managerial point of view, but not only, even from a regulatory point of view, we could say that let's assume that there is a public entities that wants to buy a tool as to support the decision-making process within the institution. In the call for finding a partner, should put some of this aspect as a way to investigate whether the tool is able or not to actually support and to do not harm the relationship that it has with its own public. On the other side, this framework could guide also the training of the employees and the training of managers related to the way they have to trust the software, trust the computer in approaching some critical decisions such as the one we are considering in our work. I want to keep the conclusion go directly to the implication, and
like with the first speaker, I gave you 5 minutes.
Yeah, just one slide. Just one slide. Yeah, okay, the last one. In fact, I skipped the conclusion because I was why is he not saying that I ran out of time? Thank you anyway. So the implication, so we should overcome the transactional perspective when institution, in this case authority, oversight authority, could embrace the use of AI for their own routinary activities, rather than embracing a relational point of view, which is based on discussion with the software providers. And in this case, we are not just talking about large language models, which are commercially diffused, but we are talking about something that is very specific, like it's a different industry, let me say, but the level of risk is still the same, the one that I used by police department as a crime prevention software. They are contracted between the police department, the US, and the software. In this case, they should move from just a transactional point of view. This also is implication in terms of bad decisions taken through the software in front of the court. So the provider of the service cannot put the, let's say, the copyright to prevent that its own software will be unpacked and see why it's taking a bad decision. Then they could adopt algorithm risk categories to prevent unequal treatment, and this is something that the EU regulation has taken into consideration. Then also embrace the idea, this is something that I said at the beginning, but it is something really important for me, maybe because I'm from the accounting field. So information is not the truth. Information is just something that generates order. So it allows us to see something through the numbers, through the words. That requires some sort of lens that we have to, first of all, to use to read the information. So information per se are not truth. And also, we should reject, this is philosophically said, as a philosophical point of view on this topic, we should reject the notion of that technology is a determinist. Since we as a human and within our institutions to shape the way technology could serve us in a way or another, and we hope that it will be used for positive social implications rather than spying or harming the health of people around the world.
Thank you. Thank you very much. Those of us, I think, who are contract law scholars, immediately recognize your reference to relational compared to transaction. There has been quite a debate, I think some 15, 20 years ago, on relational contract. The contract should not be seen as one-time transactions, but as developing relations between particular parties, and therefore demand a different approach. So your theories, your approach fits within that scheme really well. So and you did show that AI is not just a threat. Absolutely. Thank you. Good. Now, I would like to finish this session at 4 o'clock, but that gives us 5 minutes for questions. Is that okay? If I reserve 5 minutes for questions, which means we have the two. I'll see first, but the lady first, and then could you please mention your name?
My name is Neha Santansu. I'm an associate professor in civil law, and I work as a lawyer at the same time. I would like to ask my question to Professor BÜYÜKSAİŞ. You focus on the tort liability regarding to the damage caused by AI systems, but of course contractual liability can be a source of liability too. And we can sign contracts with several AI systems, providers of the several AI systems. And on daily basis, actually, we are doing this. And these providers of the AI systems are using these clauses to waive liability. For example, when you interact with a large language model, just like ChatGPT, you ask a medical problem of yours, and this model says, okay, I'm not entitled to give you medical advice, please go to hospital or seek a professional advice. But after making this statement in the contract, also there is this closure of liability waivers. But still, you can program and train these models to act as a psychiatrist or psychologist. And they are giving advice, and they are doing whatever a psychiatrists are supposed to do. And sometimes they are giving wrong advice, and they are causing damage. There are cases that these models are advising people to commit suicide or to kill another person also. And despite these clauses, these models can be liable? Can you elaborate on the validity of these clauses, where the models are using to waive the liability? Not just for the case of psychiatrists, but in general, actually.
Sure, thank you for the question. It's true that I haven't dealt with contractual issues, but depending on the contract, these exploitation clauses in business terms can be deemed void, especially if you take Article 25 of the Turkish Code of Obligations. These articles, for those who are not familiar with that, it says that if a commercial term, business term, not negotiated between the parties, create an imbalance between rights and obligations of the parties, and if it's contrary to the good faith principle, this should be void. This should be considered unwritten. So therefore, such articles, contractual articles, in the user agreements are definitely void to me. On the other hand, there are some jurisdictional problems also, because if you receive the service from abroad, which law should be applicable? Is that the Turkish law? Is that American law? you have to look at the jurisdiction as well, and then things are getting a bit more complicated. The most problematic issue to me is not only the contract, but the access to justice. When the problem happens, when the damage is there, you want to do something, you want to sue the company, but the hurdles are so important, so difficult to overcome. You have to hire a lawyer, you have to go abroad, you have to interpret all these rules. It's time consuming, it's expensive, and unfortunately, when it comes down to Turkish law, there is no class action, neither opt-in type nor opt-out type. You have to sue individually. These are the big questions. Yes, there is law in the book. It's quite different than the law in the tribunal. Yeah, I don't want to give a very detailed answer on contractual terms, but this is what I think. Thank you.
Thank you. Yes, thank you very much. Okay. Given your status, I said 2 questions, but there will be 3. But you first.
Thank you so much, Mr. Chairman. A very short remark on the presentation of Erdem. As far as I know, Swiss product liability law is modeled upon the former EU directive 85/374. Now, according to the new directive, member states, EU member states, would transform the provisions of this directive into the legislation until 9 December 2026. Now, very funny, last week on Friday, I presented a paper on the occasion of another Congress on law obligations on that topic, the differences between former and the 2 new directives, and I had some difficulties. First of all, what about the normal new directive does not use anymore producer but economic operator, and it is very difficult to translate it into Turkish because under Turkish law, economic operator means nothing. Therefore, I tried to find a new word, and I checked the German translation of the German and Swedish translations of the directive. So, Wirtschaftsakteure, economic actor, better than economic operator. Now, what about my question now? What would the new EU directive impact upon Swiss liability law? Because present Swiss liability law is more or less completely modeled upon previous EU directive.
Thank you very much. This is true, it's based on the previous European directive of 1985, the Swiss one. There are 2 things, 2 impacts could be possible. First of all, with the bilateral negotiations, Switzerland may adopt this directive into the national system. This can be possible, and this is expected. The second thing is, although Swiss courts are not bound by the decision taken by the European Court of Justice, they look at these decisions taken by the Court of Luxembourg, and they interpret the national rules in the light of these decisions taken in Europe. So I am expecting that the Swiss legislator is going to adopt this new directive because Switzerland geographically is in the middle of Europe and has commerce with all these European countries. We cannot do without, even if there is some reticence, I say, vis-à-vis this directive in Europe. There are so many questions that I couldn't cover here. They are forced to accept this.